without any further delay, I would like to introduce a friend and a true patriot and an amazing attorney, Mr. Alan Gura.
Thanks. Thanks. Thanks a lot. Thanks. Thanks. Well, thank you so much for that kind welcome and that fine introduction. And of course, we're all happy to see here at Frank is vertical these days. I bring you good news. First, let me give you the bad news, though. I cannot fix everything that is wrong with New Jersey. Yeah, you know, they say that we have 50 states, right? I mean, I know somebody was confused about that earlier. It's 50, right? And you know, which is great. We have these 50 so-called laboratories of democracy, and so we don't expect the rules to be the same in New Jersey the way they might be in Virginia or California. New Jersey is quite unique, always interesting to visit here. There's no self-serve gasoline in this state. There's no left turns for the most part. That's fine, you can experiment with that. I don't know why you would do those things. But you are part of the United States, and so some things do have to be uniform, and one of those things is respect for the Bill of Rights, including the Second Amendment, which is, in fact, part of the Bill of Rights. It is something that the state has to obey. Thanks. And I don't expect the legislature and the governor to necessarily understand that. After all, New Jersey is not isolated. You do share a border with other states. People here do travel. This is not like some island in the middle of the ocean or some backwater of Afghanistan where people just, this is the way it's always been. I know you guys know that there's this thing such as self-service gasoline and left turns, and yes, gun rights. And if those things aren't going to be done democratically, then at least to the extent that gun rights are protected by the Constitution, they are going to be done for you by the courts sooner or later. And I hope sooner these days, as we are having a very exciting time litigating the Second Amendment and exploring just what it means for the people in places like New Jersey where you guys are really not enjoying all the freedoms to which you are entitled. Let me start with a word of caution, though. There is nobody in America who is fully satisfied 100% with everything that the Supreme Court has had to say about the First Amendment or the Fourth Amendment or the 10th Amendment. And so it's not realistic to imagine that as we advance through the cases and as time unravels, that anyone will be fully happy and have their utopian vision of the Second Amendment realized. We don't live in a perfect world, and judges are humans. They get many cases right. Sometimes they get it wrong. What I can tell you, though, is that if the courts are faithful to the plan that was laid out in the Heller opinion and the McDonald opinion, if they don't veer off the path, if the courts don't find themselves composed suddenly by people who are just hostile to these cases, then you're going to see far more victories on the pro-gun rights side, and it's the other side that's going to have a lot more unhappiness to deal with. Let me go over some of the kind of gun laws that we're seeing, some of the kind of gun laws that we're seeing being challenged, both in civil cases of the type that I usually do, as well as by the criminal defense bar, which after all owes its clients zealous representation when they are charged with violating something to which they have a constitutional defense. And I'd like to go over with you how these laws should be addressed under the Second Amendment if, in fact, Heller and McDonald are followed. My comments are going to be brief because I'd like to have a lot of time for Q&A. Obviously, it's a lot more interesting to have a conversation with all of you as opposed to just sitting here and having a lawyer give you a legal lecture. So let's start with the first kind of gun law that should really be on its way out and finally and thankfully, and that is the type of gun law that simply contradicts some very basic aspect of the Second Amendment. We had one of these in Heller. Washington, D.C., unique amongst all jurisdictions in the country, had a law that said that if you had a gun of the type that they allowed you to have, you could register a rifle or a shotgun, and you kept that in your house, you were not allowed to use it for self-defense. If somebody came in through the window or broke in your door and you had a shotgun that was fully legal for you to own in your home, you could whack it, you could whack the intruder over the head with it, you could throw it at them, but the minute that you rendered it operational, unlocked it, assembled it, put a shell in that shotgun, you were committing a crime. Even the District of Columbia realized that there was some problem with this law if there was going to be a right to keep and bear arms, and so they hedged their bets in their brief. They said, well, there's no such thing as an individual Second Amendment right. They made that argument, but let's suppose that there is a Second Amendment right. They offered that this law can be read to allow for self-defense in the home. So if you read the law that way, it should be left alone and we should still be able to enforce it. And the Supreme Court said no. There is no exception in that particular ordinance for self-defense. In fact, the city had litigated against the idea that such an exception existed in a previous case. And so the Supreme Court said, nope, this ordinance forbids people from using firearms in self-defense. Self-defense is plainly a core aspect of the Second Amendment right. That's the end of the story. That ordinance is going to be struck down. There was no balancing of interests. There was no hemming and hawing. Once the court had interpreted the Second Amendment, there was really nothing left to do with that provision other than to dispense with it. We still have some laws like that in America today. I was very happy to be involved, still am involved, with the Ezel case that Frank mentioned earlier. For those of you who are not familiar with Ezel, one of the two clever things that the city of Chicago did after McDonald, as part of their resistance to the McDonald opinion, is they enacted an ordinance that said, okay, we're going to require that everyone, as a condition of having a gun, go out and get training. And then we're going to ban the training because gun ranges are now forbidden in the entire 230 square mile surface area of the city of Chicago. You cannot operate or use a gun range. This had not been the law previously. Previously, Chicago had a law that's like many cities do that said you can't discharge a gun within city limits. And of course, there was an exception for shooting a gun at a licensed club. Nothing wrong with that. Obviously, you don't want people walking out in the street shooting their guns in the air because it's New Year's or for whatever reason. That's irresponsible. But of course, you should be able to shoot a gun at a range at the very least. Self-defense, of course, is always read into that. But in any event, they forbade the ranges that were required as a condition of having a gun. Well, we sued not just arguing that there was an improper burden placed upon gun ownership because you're banning something that you're acquiring. We also alleged that there was indeed an actual right to have a gun range that you could use. What else would you do with a gun if not go out and practice, learn to use it, and go to a range once in a while at least? And the Seventh Circuit did in fact agree with that. If you read the Ezel opinion carefully, they do recognize that the Second Amendment does contain a provision for training and practice. That is obviously a core aspect of the Second Amendment right. And so we are now litigating, of course, the post-Ezel 1 regulations. Chicago came out with some more regulations. We're still suing, and we'll see the outcome of that later. There are other such laws. Illinois has another such law that we're challenging, of course. Illinois, the last state remaining that totally bans all carrying of guns by law-abiding people under any circumstances. They don't even have a may issue law. In Illinois, they simply prohibit this conduct. Obviously, the Second Amendment protects the right to bear arms, not just to keep them. And so we're challenging that. And later on, I'll explain why I think we are entitled to win. But again, that's a law that clearly just prohibits something that the Second Amendment textually protects. So you can't have that. The second kind of law that we're going to see being challenged, and we are seeing being challenged, is the kind of law that bans or restricts a certain type of gun or arm. It's important to remember that the Second Amendment doesn't just talk about guns, it talks about arms. And state Supreme Courts that have applied analogous state constitutional provisions have extended protection to knives, clubs, other things. There's a case in New York going on right now about nunchucks, martial arts weapons. Apparently, back when the Bruce Lee movies were popular in the 70s, a lot of legislatures got scared that there would be ninja armies running around America with sticks hitting everyone. And so New York, of course, well, there ought to be a law, right? So they went and restricted these types of arms. There's a challenge now, Maloney versus Rice. Good luck to Mr. Maloney on that. I hope he wins. But there is precedent for that. And it's funny, I had a continuing legal education event that I did with the Pennsylvania Bar a while ago, and I was sitting next to a gentleman from the Brady campaign, and somebody asked a question about knives and things that don't go boom, and I brought up this point, and I said, look, yeah, you can have things that aren't necessarily guns, and state courts have done this, and he just thought it was the craziest thing, because there's very much programmed to just think about guns. I said, why would you care about knives? I mean, you're talking about stray bullets going everywhere. That doesn't really happen with knives and clubs, but he just sort of rolled his eyes. But that is an area of the Second Amendment that's going to be developed more that we're going to see. But in any event, we do have these laws that bar or restrict types of arms that are out there. And again, Heller tells us that this is a kind of case that is categorical in nature. We have to define what's an arm, and once we know what an arm is this the kind of arm that the Constitution protects? After all, not everything that's spelled out in the Constitution for protection is found to be so protected. For example, perjury is speech, terroristic threats are speech, but forgery is I guess a form of speech also. But we don't protect those things, and so the question is, okay, once you've agreed that something is an arm, is this something that our historical tradition encompasses within the meaning of the right? And Heller came out with a very broad test for what constitutes a protected arm. First, an arm is something that a person can have on his or her person to use in a case of confrontation with another person. So that excludes nuclear-tipped cruise missiles and aircraft carriers and things. So I know if you've been saving up for that battleship, maybe you should just go to the car dealer instead. Fix up your house. But as far as things that you can personally carry with you, implements that you would use in case of a confrontation with somebody else, Heller tells us that we have to look at the American tradition and our experience as to what this meant to the founders. The Second Amendment does contain this reference to the idea that one of the reasons that we are we are securing the right to keep and bear arms. Remember, it's a pre-existing right. It's something you have naturally under whatever vision of rights you believe in. It's something that is pre-existing. It's not something that's created by the Constitution. It's the right that is protected. One of the reasons the Constitution tells us that we have that right is so that we can act as militia. The militia system that our government and its predecessors had relied upon people bringing with them to militia duty those arms that they had in common use at the time for traditional lawful purposes. Remember, if people had guns, it was a normal thing, and if you were called upon for duty, you would just grab whatever you had and you would then repurpose that for militia service. And so Heller said, that's good, we'll take that. The Second Amendment must therefore protect whatever kind of arms people could expect to have available to them for a traditional lawful purpose. Folks, that is broad. That is huge. Now, it's not going to get everything that every single person is going to want. I understand that. But that's a very gun-friendly test. And the test is not circular. It doesn't matter whether the government has heavily restricted something, causing it to not be in use, and then they can turn around and bootstrap that and say, well, it's not in common use anymore because we banned it, and now it's not protected because of the nature of that ban. No, it doesn't work like that. Remember, in Washington, D.C., handguns had been illegal for over 3 decades. They were not in common use for lawful purposes. They were in common use for unlawful purposes. But all the same, the court, when speaking about handguns, could say, look, a handgun, we know from the American experience, is the kind of thing that law-abiding people would want to have available to them for a variety of things, including, of course, self-defense. It's the overwhelming weapon of choice for self-defense, and therefore it's something that people's expectations must be honored, even if it's not something that the city would like to see or hasn't seen for quite some time. It's kind of like the test that we see in other areas of the Constitution. The Fourth Amendment guarantees you certain rights against search and seizure. The test for that is whether or not you have an objective expectation of privacy. Remember, if you live in an Orwellian surveillance state and John Ashcroft and George Bush are reading all your emails and listening to your phone calls, that doesn't mean that you don't have any Fourth Amendment rights. We look to the nature of your Fourth Amendment rights by looking to American history, tradition, and experience. The common use test for guns under the Second Amendment probably should work the same way. Notice what else is not important in that test. The criminal misuse. It does not matter whether criminals would really like to have these tools. Of course, handguns are the weapon of choice for criminals. If you're going to rob a 7-Eleven, I'm not telling you to do this. I'm not telling you how to do it, but we all know that if you're going to rob a 7-Eleven or a bank, then you probably are not going to be using a 50 Barrett or an AR-15, kind of large, bulky, very hard to conceal, very expensive ammunition after a while, if you care about that kind of thing, and I guess some people do. But so what? Handguns, whatever their potential for misuse, which is great, also, of course, are the essential arm that people would have with them for self-defense. Therefore, it's protected. Next, we're going to see challenges, and we are seeing challenges, much like the kind we're seeing here in New Jersey. A case I know David Jensen probably talked to you about earlier, a case I'm involved with as well. What used to be the Mueller case, now it's the Pizzetowski case. And this, of course, relates to the idea of what about these licenses to carry? Is shall issue something that we're just going to get if we prevail upon our legislators, or is that something that we are entitled to have under the Constitution? And here, I think the news is very good. First, this issue will get to the Supreme Court. Okay, I'm not telling you which case it will be because I don't know. There are many cases out there. I'm handling a bunch of them. There are others as well. But it's an issue that I believe the Supreme Court is going to deal with sooner, probably rather than later. It's too big and important an issue. And there are many courts out there already that are saying, in effect, we simply don't want to decide this. Now, I don't believe that's appropriate, but they're saying it. I guess it's more of an honest answer than to simply say the Second Amendment is limited to the home, because that's clearly not true if you look at the history and if you look at the cases. But there are some courts that will say, we just don't want to go there because we don't like the policy, we don't like the result, and so we're going to say this is above our pay grade, and we're going to not decide the case in favor of the plaintiffs. We are going to let the Supreme Court have the first crack. I think once you get a number of courts saying that, as we're seeing, the Supreme Court will oblige them, and I think that one of these cases is going to go. And once it gets there, if Heller and McDonald are faithfully adhered to, we are going to prevail. Of that, I have no doubt, so long as they stick to what they have already said. First, is there a right to carry a gun? The answer there, obviously, is yes. And in fact, this was, contrary to some of the misinformation that's being spread out there by the anti-gun people, something that's already been decided in a way in Heller. Remember back in Heller what Washington, D.C.'s defense was to the lawsuit. They asserted that the term bear arms, as used in the Constitution, is a militaristic term. It's something that means to soldier, to go off into battle. If you're bearing arms, you must be engaged in some kind of a military duty, and that informs the character of the right. That tells you that it's not an individual right, it's some militaristic state-directed right. And the Supreme Court, to resolve that question, had to examine the meaning of the term bear. Okay, Washington, D.C. says bear arms means it's a militaristic meaning. What does it really mean? And the Heller court decided that to bear means to carry. Then, as now, it means to carry, it means to have in your clothing or in a pocket or on your person somehow an arm so that you are ready and armed in case of a confrontation with another person. That is a definition. That's the law. That was necessary to decide the case. It's not simply a fluff, dicta type opinion. And even if it were for some reason not binding on future, not literally binding as a holding of the case, nonetheless, you still have an example here where the Supreme Court has told us how to interpret this part of the Constitution. It's very hard to walk into court or to be a court and disagree with that and say, well, we know the Supreme Court defined the term this way, but we're going to give you an alternative definition. And in fact, in none of the cases that I've seen so far, and I've seen a lot of them, never has the other side or a hostile judge ever said, we define bear arms to mean X, where X is something other than what the Supreme Court has said it means. They might say that the Supreme Court's words can be ignored, but they've never actually defined the term, and they have never explained how it is within the historical tradition of the Second Amendment, within the historical tradition of the right to bear arms, not something that extends to people's ability to carry guns in public. But the Heller opinion actually gives us a lot more than just that definition. Heller tells us that we interpret the meaning of the Second Amendment by looking to a bunch of sources, including, for example, early state constitutions, and then it lists a bunch of them, and lists a bunch of opinions that interpreted them. Go read those opinions. In many of those cases, the facts of the case were that somebody was carrying a gun outside the home for self-defense, and the courts recognized that right, and they found that this was within the meaning of the traditional right to arms. Heller also tells us that there are certain exceptions to the right to carry arms, and these are exceptions that all prove the rule. For example, Heller says you can't carry a gun into a sensitive place. Okay, we don't know what a sensitive place is. They did not tell us how to find that out. And intuitively we know that there must be some sensitive places out there. For example, you're not going to be able to carry a gun into the sterile area of an airport. Okay, not going to happen. You probably have to check your bags at the counter. You're probably not going to be able to carry a gun in a hall where the President of the United States is speaking. There's going to be a metal detector. They're probably going to prevent you from walking up to him with a gun. Okay, sensitive places. We can leave for later the idea that these things exist. Well, what's a sensitive place? Well, that's the exception that proves the rule. Of course, if there are sensitive places, there must be some places that are insensitive, non-sensitive, right? But beyond that, Heller gives us two other exceptions that have a lot of substance behind them historically and within the law. First, Heller tells us that there's an historical prohibition against carrying dangerous or unusual weapons. Okay, a lot of people have read that and they say, okay, I guess there's some crazy things you won't be able to carry. And perhaps that's true, but if you read the language carefully and if you read what those opinions and treatises tell you, that's not so much a rule about the types of guns that you can or can't have. That's actually a rule that relates a lot to the conduct that you can and cannot engage in while you are armed. It refers to what the English called hundreds of years ago the common law crime of affray, where it was a crime for people to go armed to the terror of the public. And that terror to the public exception was always a very important one, because English courts by the time of the American Revolution had recognized that you couldn't read that law to bar people from carrying guns if they were doing so peaceably, and if they were simply going armed for purposes of defense. There had to be some extra ingredient that was terrifying to people, aside from the fact that someone had an arm with them. And that is something that the cases recognized throughout American history. Heller cites a great number of sources for this, and I'm not going to bore you with this chapter and verse. You can go read the briefs. They're being filed, but that is definitely an aspect of the Heller opinion. And of course, the other thing that Heller tells us is that historically, it was okay to prohibit the carrying of concealed weapons. Okay, that is true. Historically, courts upheld prohibitions on the carrying of concealed weapons, but that doesn't mean you don't have the right to carry a gun. If you read those cases, and Heller quotes them extensively, they all stand for the very simple and obvious proposition that the state can regulate the manner in which you carry a gun so long as they don't obliterate the right completely. Now, in the 19th century, it was thought that people who concealed their arms were sneaky, they were up to no good, they were looking for an unfair surprise, or the advantage of unfair surprise over their victims, because of course virtuous people at the time wore their guns openly, and that was not seen as a big deal. And so case after case after case would say that the state can prohibit concealment, because concealment is something that society didn't want to accept at the time, so long as it did not ban all carrying of guns. And in those cases where all carrying was banned, or an indictment did not specify that the person was carrying it in some sort of evil manner, then in those cases the government lost. And that should be continuing today. Now, does that mean that you have a right to carry openly and not a right to carry concealed? No, it does not mean that. It means you have the right to carry a gun, and it means the state can regulate the manner in which you do so. It doesn't mean that you have the right to do it in any specific way. And in fact, we've seen examples in modern America where the old 19th century preference has shifted. We have a lot of states that are very gun-friendly, places like Texas, Oklahoma, Florida. These are not anti-gun places. You cannot run for statewide office and be perceived as being anti-Second Amendment. They're very easy to get permits to carry concealed guns in those places, but they all forbid open carrying. That is a policy choice that they are going to be allowed to continue. But what do you do about a place like New Jersey? My guess, you guys all know better, you live here, I don't. My guess is that in New Jersey, if you told the legislature, look, you're going to have to allow the carrying of guns, how would you like to have this done? I'm pretty sure, you can all correct me if I'm wrong, that the legislature here would prefer that the guns be concealed. I don't think that New Jersey state officials want to see the open carrying of guns. But if they want to do it the other way, I suppose Heller and McDonald would allow them to do so. But what do we do about the licensing? Can they require a license, and can the license be something that's up to some official's idea of whether you have a good cause or a moral character to have the license? And here the answer is not so much found in Heller and McDonald, it's found in much older cases, all of which are consistent and say the same thing. When you have a freedom guaranteed by the Constitution, and we know that the right to carry a gun is a freedom guaranteed by the Constitution, the government can only license that subject to objective standards. There cannot be any room for opinions or fact-finding. There cannot be any room for what the courts have condemned as unbridled discretion. After all, if you have the right to do something, you don't have to prove to anybody that you are a good enough person to enjoy something that is your constitutional right. That doesn't mean that you can't have any licensing. We license speech all the time in this country, probably too much. You know, if you want to get married, you're going to need a license. If you want to broadcast, you got to talk to the FCC. You have a right to travel, but you're going to be required to get a driver's license and a pilot's license. That's fine, but none of those licenses are up to anyone's idea of whether or not you deserve to enjoy your rights today. And so discretionary may issue laws should be struck down by the courts as an unconstitutional prior restraint. I really do believe that, and that's how we argue the cases. It's not a matter of balancing. You know, the other side always wants to balance everything. They say, well, on the one hand, okay, you've got this right, but it's really crazy. And here's a stack of criminological studies that the sheriff and all of our friends in the faculty lounge are going to bless, and they're going to say that it's too dangerous and wacky to allow. Folks, that's not important. You know, the Supreme Court has been extremely clear in Heller and McDonald. We don't use any of these interest balancing mechanisms that lawyers come up with to determine the contents of your constitutional rights. The Constitution already reflects the people's balancing of interests, and if you want to have that kind of discussion, I guess you can call a constitutional convention and talk about it. Good luck. But once the right is in the Constitution, it's no longer something that you can weigh one way or the other to see whether or not it truly is something that should be applied. You do use balancing sometimes when the history doesn't tell you what to do with a regulation that impinges upon a right that you recognize exists. And there's a role then for that kind of analysis, but that is not the issue here. The issue here is you have the right to carry a gun, and it's not something that is to be balanced to see whether it exists, and it's not something that you have to prove your entitlement to as an initial matter. Anyway, I think I've probably spoken for long enough. I could probably talk to you for another couple hours, but I'd like to really open it up for questions, and so we can have a conversation in this. I'm sure you guys all are interested in hearing some Q&A. So thanks so much. Thanks.